Good evening, everyone. Good evening, everyone. Making sure everyone's wide awake this wonderful evening. I am Ebony Nelson. I have the honor and pleasure of serving as Dean of this wonderful law school. And on behalf of the University of Connecticut School of Law faculty, staff, students, and alumni, it is truly my pleasure to welcome you all to this very special event honoring our very own Professor Kyle Brennan Marquez and his investiture as the Wallace Stevens Professor of Law. I extend a special welcome to Professor Brennan Marquez's family and friends, Therese and Thomas Brennan Marquez, Hillary Brennan, Nate Moyer, Carly, Matt, and Betty Zabreski, and last, and this is a quote, obviously most important, according to Kyle, his and Carly's wonderful daughter, Tala. Welcome to you all. Thank you all so much for being with us this evening. I ask that you please join me in thanking our amazing Associate Dean for Faculty Development and Intellectual Life, Ann Daly, and our wonderful events, ITS, catering, and facility staff, all of whom worked so very hard to make this lovely event possible. Please join me in welcoming and thanking them. This evening is an opportunity to come together as a community to express our appreciation for Professor Brennan Marquez's role at UConn Law as a phenomenal teacher, an outstanding scholar, and a committed community member. The Wallace Stevens Professorship was established in 2006 and is named for an accomplished attorney, businessman, and poet who lived right here in the West End of Hartford, Connecticut. A successful insurance company executive, Wallace Stevens believed that contemplation should be the poet's instrument. I'm not sure if Professor Brennan Marquez shares Attorney Stevens' talents in the poetry writing arena, but as a leading scholar in areas including but not limited to artificial intelligence and technology in the law, evidence and the criminal legal system, and political speech and election law, he embodies the modified belief that contemplation should be the scholar's instrument. A graduate of Pomona College and Yale Law School, Professor Brennan Marquez joined the UConn Law faculty in 2022 after having served as a research fellow, adjunct professor, visiting associate professor at Yale, Georgetown, and NYU law schools. And I just realized that 2022 is not correct, Kyle, is it? Yeah, that was tenure. Thank you. Sorry about that. During his time at UConn Law, he has proven to be an exceptional educator. Students in his courses, such as constitutional law, evidence, law and technology, and civil and criminal procedure, appreciate his encouragement of independent thinking and creative solutions. They applaud his excellent practice of the Socratic method. You don't hear that every day. And his efforts to ensure that they have a good understanding of what can so often be very complex concepts. To quote a few of his students, Professor Brennan Marquez is very friendly and made first semester of law school not as scary as I thought it would be. I loved the first class, and from then on, you were great. And KBM is a great professor who really wants his students to succeed. Not only is he an amazing scholar and educator, Professor Brennan Marquez is also a giving and engaged colleague whose dedicated service to the law school, academy, and broader community helps to advance UConn Law's mission and goals. He served as the inaugural director of our Center for Community Safety, Policing, and Inequality, and has chaired important committees, such as the Faculty Appointments Committee. He is a constant mentor, supporter, and friend to his colleagues who has greatly contributed to their success and the success of the law school. Kyle, on behalf of your family, friends, colleagues, and students, I congratulate you on this wonderful achievement that recognizes your excellence as an exceptional scholar, dedicated teacher, and engaged member of our community. I thank you for your many contributions to UConn Law and beyond. We are immensely proud to have you as part of our community, and we all look forward to your lecture on mercy, justice, and artificial intelligence. Thank you so much, and congratulations, Kyle. At this time, I welcome Professor Michael Fischel for his introduction. Thank you.
Thank you, Ebony. What do law professors do? My favorite answer to that question was offered by the daughter of my first-year contracts professor when asked during a kindergarten exercise what her father did for a living. She reportedly responded without missing a beat, "He teaches ducks to quack." Whatever deep insight there is to that observation, it is her focus on what her law-professing father was doing in the classroom that interests me this evening. If you ask the relatives and the students of law professors, in other words, the two populations who typically see the most of us on a regular basis, just what it is that we do, chances are the classroom will loom large in their response, since it's by some distance the most visible dimension of our work. Indeed, in my own early years in the profession, one of the greatest challenges in dealing with family and friends was convincing them that I was actually busy even when I wasn't in the classroom or heading for one. As I labored one hellish Miami summer on an article that was critical to my tenure vote, I had to cancel plans to visit my parents and siblings in Chicago. My mother, God rest her soul, did not conceal her disappointment and replied acidly, "Well, dear, I hope they are paying you for that." "Not much," I replied, "but if I pull it off, I'll get to do it again and again and again for the rest of my life." The point then is that so much of what we do in the scholarly life, we do alone. To be sure, the public dimensions of our work, classroom teaching, conferences, symposia, are intensely social. But as we madly prep for class, and as we nurture our written work to fruition, our principal companion is a desktop, or a laptop, or a tablet. And even the large stack of books, reprints, and photocopies that at one time kept us company, offering physical evidence that we were not, in the end, bowling alone, now reaches us through the wonders of liquid crystal display, reducing all that scholarly work to its lowest digital denominator and enabling it to stare at us in the eye as we labor. We're here tonight to honor a truly extraordinary scholar, and I am so very fortunate to add my dear friend, Kyle Brennan Marquez, on the occasion of his investiture as the Wallace Stevens Professor of Law. Kyle is the Legal Academy's ideal version of a utility player, combined with the Energizer Bunny, and he will always be Professor Everything to his colleagues. He is, as the dean said, a gifted classroom teacher whose grateful students have bestowed on him an honor that was once the exclusive province of larger-than-life presidents of the United States, right? He will always be KBM to his students. Need someone to chair a committee? No one is better at identifying and revealing the emperor's nakedness. yet at the same time making the task of negotiating the maze of clueless administrative protocols seem like fun. Let me tell you how much fun. I was on that faculty appointments committee after a very tumultuous period, and Kyle made us prisoner of war bracelets to commemorate the service that we would hold up in solidarity when we would meet. Looking for a scholar whose work is brimming with insights that rethink the old and pre-think the new? Kyle's your huckleberry. And here I'll offer but one example from a long and growing list. His marvelous article on microcosts, co-authored with Brendan Marr, a beloved UConn expat. It's an extended meditation on the time and bandwidth devoted to increasingly ubiquitous bureaucratic rituals, representing the unceasing efforts of our digital overlords to force the square peg of human activity into the round hole of the next annual report, and to justify their own existence by requiring the rest of us to count and measure countable and measurable pseudo-proxies for the uncountable and immeasurable work that we actually do. In deeply theorizing this dimension of contemporary life and in giving the source of oppression and alienation a name, Kyle and Brennan have succeeded in much the manner of Catherine McKinnon, who first taught us to recognize that sexual harassment was a thing, that there was a politics to that thing and it wasn't pretty, and that critique and even resistance might be possible. But it isn't the content of microcosts that's the principal focus of my remarks tonight. Instead, it's the fact of co-authorship and what that represents in Kyle's work and in his unique and incomparable contribution to this community. Simply put, on a faculty blessed with a host of generous colleagues and gifted scholars, what stands out is Kyle's commitment to the social dimension of the academic endeavor. We see this in his many co-authored publications. In addition to microcosts, there's the wonderful article on demeanor evidence with Julia Simon Kerr, another extraordinary classroom teacher whose students have honored her with a 3-letter appellation. There is also a finely wrought essay, this one written with Doug Spencer, yet another beloved UConn expat, arguing that voters need buffered time every bit as much as they need buffered space to enable safe, responsible, and deliberative exercise of the franchise. Not to mention a host of other essays and articles and reviews addressing an extraordinary range of topics, and each a fruitful cross-pollination with a carefully chosen colleague so that the publications section of his CV reads like a travelogue of Kyle's interests, associations, and institutional affiliations. We see the social dimension as well in his unceasing scholarly engagement here at the law school, where he has energetically organized reading groups of various shapes and sizes and topics to the delight of all. I close with a story. Progress toward tenure deliberations are ordinarily the academic equivalent of deep state proceedings, kept in confidence until the end of time. But I will never forget when, early in Kyle's career at UConn, the senior faculty met for the first time to discuss his progress toward tenure. We gathered in a small meeting room here in the Starship, and then did as we do and began seriatim discussions of the progress of each of our junior colleagues. When we got to Kyle, someone piped up straight away that they'd been enjoying a fascinating series of conversations with him on a topic of particular interest to the speaker, and that Kyle was brimming with insights and ideas prompting the speaker to rethink some matters in his own field. A second colleague spoke at that point and revealed that, remarkably enough, She too had enjoyed this experience, on a different topic, of course. But the Kyle was uncommonly well-versed in the literature and again brimming with ideas that might or might not find their way into print, but that the continuing conversation was a thrill. To our increasing amazement and eventual amusement, no fewer than a third, a fourth, and a fifth colleague spoke up to report precisely the same phenomenon, offering similar accounts of deeply substantive engagements with Kyle on a broad array of substantive topics. As I recall, our discussion of Kyle came to a close when someone said, probably me ever eager to end a committee meeting. Can we just give him tenure now? For his many extraordinary contributions, it is Kyle's leadership by doing with respect to the collective life of the mind that is the standout feature to me. We are lucky to count him as a colleague, and whatever we call him, I give you Kyle Brendan Marquez.
All right. Good evening, everyone. Thank you so much for being here. I want to especially thank Ebony and Michael for the lovely remarks, as well as Ann Daly, Deb King, everyone else in the events office who actually worked to make this whole set of festivities possible. I want to give them another round of applause. Thank you. I'm going to be talking this evening about the question of artificial intelligence in the legal system. Obviously a hot-button issue, particularly given recent advances in large language models, as well as ongoing developments around the next generation of legal research and writing tools. I see many of my current students in the room and recent alumni. Can't help but think, all of you are entering a profession here where, going forward, and not too long, the entire enterprise is going to be mediated, if not defined in some large measure, by AI. So I think we're all aware of these developments in a kind of ethereal way. We're living through this transformation right now. My goal tonight, against that backdrop, is going to be to take a step back and think a little bit more systematically and formally about what sorts of legal questions we think are amenable to automation in principle. That is, what kinds of legal judgments do we think are the sorts of things that, in theory, once the technology gets good enough, could be delegated away to machines? And for purposes of answering that question, or at least for purposes of the present lecture, I'm going to encourage us to not get too hung up on where current AI technology is, or even where it's likely to go in the near or medium term. Instead, what I want to do, or I'm going to invite us to do here tonight, is to project forward on purpose and consider some of the more outlandish, even borderline utopian promises of what AI's eventual capability will be. This kind of starry-eyed stuff that comes out of, the Silicon Valley. Really kind of grand claims. And I want to think about, in that world, if that ever came to pass, if we're talking about a situation where AI really does match or even vastly surpass human dexterity in the face of complex interpretive problems, would there still be reason to retain human control over certain kinds of legal judgments? Is there something about certain kinds of judgments that seems to necessitate a human touch, so to speak, all the way down? So that's where we're eventually headed tonight. To get there, we'll first be laying some groundwork. I'm going to start by talking at some length about the concepts of mercy and justice and the exact relationship between them, a puzzle that has preoccupied theologians and philosophers certainly, but also lawyers and judges for a very long time. Then we'll move to a bit of political theory, thinking about the connection between mercy and democracy. And I'll suggest that on a certain account of democratic self-rule, in fact, a very familiar, I think, and appealing account, excuse me, the room for mercy in legal decision-making could be understood as integral to the very sense, the kind of lifeblood of political freedom as an ideal. And then from there, at last, we'll move to the ultimate question, the sort of question posed about the role of artificial intelligence in the legal system going forward. Okay, but where I want to start to get the ball rolling with something a little bit more concrete, a case that we can all sink our teeth into together, just like we do in the classroom, is with a familiar example from popular culture, the case of Jean Valjean from Les Miserables. So, as I'm sure many of you are familiar with, or in case you've never heard of Les Miserables, or it's been a while since you've seen the show, read the novel, Jean Valjean is serving time, a long sentence, for stealing bread to feed his starving nieces and nephews. And when we first meet him in the story, he's in the process of being paroled for that offense. So what I want to do here is imagine Jean Valjean's case as a contemporary criminal trial. So same underlying facts. Valjean is being prosecuted and tried in some jurisdiction in the United States of America in 2026 for bread larceny under the jurisdiction's bread larceny statute. And he wants to testify in his own case. Valjean wants to take the stand. He wants to exercise his Fifth Amendment rights. So the question is, what kind of defense is Valjean going to offer? When he takes the stand, what is he going to want to say to the jury? What form of defense is he going to marshal in order to try to secure an acquittal? To begin with, I think we can see pretty clearly that Valjean isn't going to offer any kind of defense that's related to the elements of the crime, right? He's not going to say, you got the wrong guy, I didn't do it, it wasn't me, or it was an accident, I thought that loaf of bread belonged to me, or anything like that. He's going to offer instead a different sort of defense, and I think we can divide the possible defenses that he might offer into two types, or two sort of substrands, one of which will track the concept of justice, and the other of which will track the concept of mercy, and then we can see how the two fit together. So the first kind of defense that Valjean might offer, which is very familiar to our legal system and many legal systems, is a species of necessity. So he might say, look, I did it. I'll concede. All the elements of the crime are satisfied here. I broke into the dwelling. I had no permission to enter. I took the bread. It wasn't mine. I did it all on purpose. I wasn't in some kind of fugue state or, sleepwalking when I did it, okay? You got me. But Valjean would want to continue. He'd want to take the stand precisely to say, here's why I did it. He'd want to offer an account of the conduct that attempts to recharacterize it as undeserving of punishment in light of its particular circumstances. And this sort of defense is far from exceptional in practice. Criminal defendants are developing defenses like this all the time in courtrooms throughout the country. Whatever its specifics, depending on the facts of the case, the point of this kind of necessity defense is it gives the defendant an opportunity to argue, look, I did something the law forbids. I'm just going to concede that. If you applied the law mechanically, in my case, in other words, it would reach. However, once you examine the facts more closely, you'll see that an exception is warranted, or at any rate, that's what I'm going to argue, that the law should treat my case differently. In this sense, we could say that a necessity defense like this is designed to prompt the jury to imagine and apply a kind of refined version of the law, a counterfactual version of the law that doesn't just simply blanketly prohibit things like bread larceny, but instead starts to distinguish in a more fine-grained way between different instances of conduct in that category. Okay, so that's one kind of defense Valjean might offer, the necessity defense. But there's also a second kind of defense, and the difference between them is qualitative. It's a matter of category, not just degree. With this second kind of defense, Valjean would not be arguing for a refinement of the law as applied in his case. He wouldn't be arguing that his conduct, despite formally qualifying as bread larceny, is undeserving of punishment. Rather, he would be asking for forbearance. He'd be begging for mercy, as the phrase commonly goes. In other words, he would be saying, look, even if, or even on the assumption that, I am guilty, I did do this, and punishment would be just, you should spare me anyway. To bring alive this kind of defense, Valjean might say things like, I know what I did was wrong. I made a grave mistake. I did in the circumstances something that many of us no doubt would have done, and at the time it seemed like the only option I had, but now I realize the error of my ways. Please, spare me this terrible ordeal. Please make an exception. I beg you, take mercy on me. So whereas with the first type of defense, the necessity defense, Valjean would be conceding in a sense that his conduct satisfied all the elements of the crime, but he would not be conceding his culpability. The whole point of the defense would be to cast doubt on his culpability. The second type of defense goes further. It would involve a concession not just of all the elements of the crime, it would also, in its conceptual structure, concede at some level that he is culpable and that punishment would be warranted. And it would ask the decision maker, the members of the jury, to show restraint anyway. to extend Valjean greater lenience than he deserves. This indeed is axiomatic of mercy. Unlike justice, it's never a matter of desert. It's always a matter of grace. In fact, we can reframe the two defenses, or we can formalize the distinction between them more precisely along just these lines. The first form of defense, we might say, develops an argument about justice. It asks the jury to regard the routine application of law in Valjean's case as unjust, which is to say it embraces desert as the determinative variable. I should say desert with one S, obviously, here, right? And it argues that under the circumstances, Valjean does not deserve punishment. For what it's worth, this dynamic, making an argument about why punishment is not deserved based on the particulars of the case, generalizes to all of the traditional justification and excuse style defenses that one learns about in a first-year criminal law course and that many lawyers are also quite familiar with: self-defense, defense of others, insanity, that sort of thing. Valjean's second defense, by contrast, takes the form not so much of an argument as an entreaty, and it operates on the dimension of mercy, not justice. The second form of defense, Valjean's plea for forbearance, doesn't ask the jury to see the routine application of law in his case as unjust. It doesn't try to recharacterize his conduct in the richer light of its particularity as undeserving of punishment. Instead, it rejects the very notion that desert should be the determinative variable. It asks the jurors to set aside what's deserved on purpose. It implores them to look elsewhere, somewhere beyond justice, for the proper resolution of the case. Now, of course, in a real-world version of this case, the equivalent of Valjean, an actual criminal defendant facing trial for bread larceny under these circumstances, would almost certainly offer both of these defenses at once. Or maybe, better put, the defenses would tend in a real-world trial to run together naturally and maybe become functionally inseparable, because the kinds of factual observations and moral sentiments that Valjean would offer on the stand, talking about the suffering of his family members, describing his own anguish at the moment of decision, that sort of thing, would tend at one and the same time to support both an argument about the injustice of applying the law too rigidly and a plea for mercy, even assuming punishment was just. And once again, at a practical level, the jury would express agreement with either of these defenses in exactly the same way. It would acquit Valjean. The jury would not be unburdened to explain why it was acquitting. The acquittal would simply be the end of the matter, whether it reflected the belief that the jury thought Valjean's conduct was justified and so undeserving of punishment, or because it reflected the jury's wish to extend Valjean mercy in spite of the punishment that he did in fact deserve. If the jury took the first view, if it agreed with his necessity defense, it would acquit him in the familiar way of finding him not guilty under the law. If it took the second view, by contrast, if it believed Valjean was guilty but elected to show him mercy anyway, it would acquit him in the sense often described as nullification, which is formally disallowed in our legal system, but also curiously, and I would argue fundamentally for very, very good reason, hardwired into the structure of criminal trials. We wouldn't be able to rid ourselves of nullification, to eliminate this kind of space for mercy on the part of juries, even if we wish to. In any event, my point here is not to focus or fixate too much on juries or jury verdicts as the exclusive place where we see this intertwining of arguments about justice on the one hand and pleas for mercy on the other. To the contrary, every site of discretion in our criminal punishment system, police deciding which cases to write up, prosecutors deciding which cases to bring, juries deciding conviction or acquittal, judges deciding on sentences in the event of a conviction, heads of state deciding whether to extend clemency, and so forth. All of these decision points invite the same dual form of advocacy on display in Valjean's case. At each juncture, in other words, there will be room for the person in Valjean's position to argue some version of, wait a second, justice requires treating my case differently, but also, at the very same time, to implore the decision maker to show mercy, even if they remain totally unmoved on the question of justice. The key, though, is that conceptually, Valjean's two forms of defense, wherever they might arise, at whatever point in the process, track qualitatively different senses in which the law can fall short. The first defense, his necessity defense, is about enriching context-insensitive rules, making the law more nuanced, more supple, better able to differentiate between fine distinctions within familiar categories. Stealing bread sociopathically versus stealing bread to feed your family. Stealing bread to feed your family because you forgot your wallet at home and it would be incredibly inconvenient to go back and get it, versus stealing bread to feed your family because there are no jobs and everyone is starving. That sort of thing. But by the very same token, the logic of a necessity defense suggests that the defense would become unnecessary. The space for it would, so to speak, disappear if law were already more refined. If the law specified perfectly what to do in cases like Valjean's, if it already embedded a full slate of criteria for drawing the right kinds of distinctions between different versions of bread larceny, then there would be no need for his necessity defense. Indeed, at some level, there would be no need for any justification or excuse-style defenses because the context insensitivity these defenses facilitate would already be woven into the normal operation of law. Okay? The second form of defense is not like this. If Valjean implores the jury to show him mercy, he's not pointing to a lack of refinement in the law. He's not saying that the law, as codified, gets his case wrong. Rather, Valjean is inviting the jury to suppose that the law gets his case right, that it would be just to hold him to account, but that nevertheless the jury should not. The space for this defense, unlike the first, would not disappear, so to speak, through further refinement of the law, because the problem it highlights is not with the law's content at all. The point is not that law is miscategorizing Valjean's case. The point is that even if the law is correctly categorizing Valjean's case, that categorization by itself does not tell the jury how to proceed. This would be true no matter how refined the law became. It would be true even if law were to become a perfect instrument of justice, because it's about whether, in principle, considerations of justice should determine the case's outcome. This is the sense, I think, in which Thomas Aquinas famously described mercy as inherently more than justice. That's St. Thomas's formulation, which we're going to work with for the rest of the lecture here. Mercy is more than justice. On this account, mercy supplements justice, and the two certainly seem to have a kind of affinity, but they also never transpose or collapse into one another. They are at all times distinct. And for what it's worth, this is also the idea of mercy on offer in one of its most famous cultural depictions, Shakespeare's The Merchant of Venice, the famous scene where Portia, at that point disguised as a lawyer, implores Shylock to show mercy to his debtor, Antonio, mercy that is by hypothesis, and as Portia forthrightly and explicitly concedes at the outset of her famous speech, more than Antonio deserves. Indeed, that's the whole point. Mercy is always undeserved, always freely given. Unlike justice, mercy is never a matter of compulsion. It's always a matter of discretion. Of course, this doesn't mean that with mercy anything goes. There are general principles and heuristics that can and often do guide its application, some of which show up in positive law, for example, in things like sentencing guidelines. But there's something ineffable about mercy at its core. There's a sense in which, as an act of grace, its exercise can never be fully elucidated or constrained. At some point, unlike with justice, the reason-giving process will simply run out. For mercy is, at bottom, an indeterminate, unruly, radically free kind of act. Okay. But now, the age-old puzzle, the one that I said has long preoccupied theologians and philosophers, can come more fully into focus for us. If mercy is more than justice in this sense, then how exactly do the two fit together? To be sure, we often experience them and would talk about them informally as compatible virtues. Many of us, I imagine, would be comfortable, if not proud, to identify both justice and mercy as virtues that we aim to cultivate in our everyday lives, teach our children, expect of our friends and loved ones and neighbors, and so on. But the deeper sense in which mercy and justice reconcile is far from self-evident. Indeed, if we try to pin the concepts down, they can quickly start to feel more oppositional. From a justice perspective, mercy can easily seem like a kind of deviation, a subversion of the rules that we've all agreed to. After all, if the core of justice at some level is the idea that like cases should be treated alike, well, the supposition of mercy is that sometimes purely discretionary, radically free exceptions will be made. in what sense is mercy not simply a species of injustice? Or put the other way around, perhaps we could say, why in the first place does justice even require supplementation? Shouldn't justice itself, once fully expressed, perfectly expressed, be enough? Isn't perfect justice, after all, the organizing goal or some kind of grand telos of our legal institutions, at least as we normally conceive of them? On the other hand, from a mercy perspective, justice can easily seem like a cold, austere, even callous virtue. Not that justice is non-virtuous, but that by itself, left to its own devices, so to speak, it seems to be missing something important. Justice in the total absence of mercy, I mean, think of the linguistic formulation, merciless justice, is a kind of inhumanity, or at least a degraded form of humanity, notwithstanding the pressing human desire for justice. As philosopher Martha Nussbaum once wrote, if we set high standards of good action for ourselves, the very course of life will often make it difficult for mere human beings to measure up. And this confronts us as a human community with a deep and persistent dilemma, I think. We can either set lower standards of good action, which will mean resigning ourselves to something less than full justice, or we can maintain high standards of good action. We can insist on justice in its fullest sense, as I believe we ought to give the ideal its due, but also recognize that exceptions will be necessary, that some degree of case-by-case forbearance will be required to soften the sharp edges of justice, even if those sharp edges are part of the shape justice takes in our world. To frame all of this business about justice and mercy and their potentially fraught relationship into a single integrated line of inquiry, we might say something like the following. What role, if any, is left for mercy once justice is fully realized? If legal rules were to become maximally refined, such that they fully captured the granularity and complexity of particular cases. In other words, if we were ever to reach the point where the room for defenses like Valjean's necessity defense were to disappear because the law's operation would no longer need this kind of case-specific refinement, at that point, would mercy still matter? Would there still be something at stake in decision-makers being able to set questions of desert to one side on purpose and extend defendants like Valjean more than they deserve? Not as a matter of justice, precisely not as a matter of justice, but as a matter of grace. In the remainder of this lecture, I confess I'm not going to furnish a full, or at least a fully satisfying answer to this question. For one thing, I need quite a bit more time up here. I'm not going to take a poll, but I imagine there'd be a mixed appetite for that. But more fundamentally, it's a question about which I'll confess to being deeply ambivalent myself. I'm not sure of the answer to this question. Ultimately, I think it depends on a fundamental issue of political theory. What does self-determination as the first principle of democracy entail? What is the essential character of political freedom in the grand but elusive sense promised by democratic self-rule? At a minimum, I'd say, political freedom must mean that we get to decide for ourselves, working collectively through legitimate channels, of course, what we take justice to require and what laws, specifically, we all wish to live by. That's plainly part of what autonomy in its classical sense conveys. The word itself comes from the Greek, autonomos or autonomia, and it translates directly to laws of our own. So that much, I think, is fairly clear and uncontroversial. Part of democratic self-rule has got to be that we get to choose our own laws, that law is something that we fashion together, not something imposed upon us from without. The harder question, I think, is whether self-determination entails something beyond this, whether in the course of determining our own political fate, autonomously, as a people, as a polity, it's not simply that we all need to share in the creation of laws, it's also that decision makers who execute those laws in our name, whether we're talking about juries or judges or any other kind of official, that those decision makers get to decide just as freely. In other words, in a manner that just as much expresses our sense of collective autonomy, if and when to make exceptions. In other words, does self-determination as the anchor of democratic life manifest exclusively at the level of formulating rules, or does it also manifest at the level of individual judgments about whether those rules, as formulated, ought to apply in particular cases? Let me pose the question slightly differently, though it's the same question at core. When a decision maker charged with wielding public authority, again, whether we're talking here about juries, judges, or anyone else, when that decision maker says no in a particular case, when she declines to apply the law, not just refining the rules to make them more responsive to the particular facts and circumstances, a la Valjean's necessity defense, but more fundamentally, more radically, disregarding the rules, setting aside considerations of justice in a truly discretionary way, is that act an independent expression of political freedom? Does the possibility of mercy in this way contribute fundamentally to our felt sense of what it means to be politically free, what it means to be self-governing people, the sense that it's up to us as an autonomous political body to decide not only which laws we want, but also whether and when those laws should yield to grace? Now, as I said, I'm not going to answer this question to full satisfaction here. What I will try to do, though, by way of concluding, is try to sketch what I take to be the implications of our answer to this question for the question of artificial intelligence broadly and the proper role of AI in our legal system. Okay, so here we go. We're building toward the climax here. All right, so thinking about the question, if justice is the be-all, end-all of democratic self-rule, if in the end our sense of political freedom is exhausted by the activity of coming together as free, co-equal subjects and determining which rules we wish to live by, then my sense is that turning decision-making power over to machines faces no existential objections, but it does confront two very important practical concerns and hurdles. The first is simply about institutional design. This one should be somewhat familiar. Even in settings where it seems like judgment could be automated without losing anything essential. So I'm thinking, just to take like a concrete paradigmatic example, like red light cameras, parking enforcement, stuff that in the actual world is largely automated in many places. There still might be powerful governance reasons to favor human involvement of some kind. As we all know, automated systems, even fairly sophisticated ones, can make mistakes, they can be hackable, they can become too easy to circumvent. There are a lot of problems, many quite familiar, that go into this kind of governance bucket. Okay, so that's one set of practical concerns. The second set of practical concerns, and again, this is on the assumption that justice is the be-all, end-all here. That's if you answer the question that way, that it has to do with the nature of rules themselves. We might simply be skeptical that rule systems could ever be sufficiently complete or completable, that their implementation in practice could really be automated. After all, we have many mechanisms in our legal system, some with very deep historical roots, that are designed precisely to adjust course rules in response to the messiness and unpredictability of real life. In the past, we've had entire separate institutions like the chancery courts, whose sole function was to do this. And although we don't have chancery courts in the same way anymore, their spirit lives on in many different guises: equitable remedies, prosecutorial discretion, the list goes on and on. We can talk more about it in Q&A perhaps. But against that backdrop, the point is, one might simply conclude that justice at some level can't be perfected, or at any rate, we haven't seen any version of justice in the long arc of human history that seems anywhere close to perfectly refined in this way. So if efforts to automate justice are premised on its perfectibility, it might just seem like a non-starter, at least for the time being. Okay, so that's what I take to be the implication, broadly speaking, if justice is sort of the only game in town here. If justice were perfected, there would be no room anymore in principle for mercy, if that's our answer to the fundamental issue of political theory. If, on the other hand, though, the answer runs the other way, if mercy is in fact integral to our sense of what it means to be politically free, if self-rule requires maintaining the possibility that even perfect laws, even a perfect instrument of justice, may have to, on occasion, yield to grace, then the situation is quite different. Then I think implementation by AI, or the delegation of implementation authority to AI, does face an existential objection. And this is actually for a fairly straightforward reason, now that we have the categories of mercy and justice in sharp focus. As I've said at various junctures tonight, mercy is never a matter of desert, it's always a matter of grace. But another way of putting that is that mercy's conditions are genuinely unknowable and unverifiable. The exercise of mercy is a radically free act, which means there is no right answer, even in principle, to the question of whether someone ought to receive mercy, whether Valjean or anyone else should get more than they deserve. This means that AI will simply have no criteria by which to exercise mercy or not, in the very same way that humans lack definitive criteria to guide the exercise of mercy. Of course, we'll certainly be able, if we choose, to engineer thresholds of undeserved lenience or kind of randomized lenience into machine systems. Indeed, this is something technologists are already working on to make them sort of softer or more palatable in their application. Though, of course, for one thing, we don't actually need any fancy technology to do that. Something like coin flips would work just as well and have historically in settings where we think fairness requires things like randomization. But the more fundamental point, of course, is that randomized lenience is not the same as mercy. Although a plea for mercy makes no claim of entitlement on the decision maker, it's also not a mere invitation to arbitrariness or whim. It implores a decision maker as a free moral agent to make an exception. It asks them to look beyond justice for the proper resolution of the case. But this landscape, this locale beyond justice that it asks the decision maker to explore is not simply a void or some kind of infinite unstructured expanse. It's a deeply human place, a very familiar, if often uncomfortable place. The type of deliberation it involves immediately and unavoidably conjures to mind the reciprocal sense of frailty and vulnerability that we all experience as human beings. Like, imagine if you were actually on a jury in a case like Valjean's and the defendant is looking at you in the eyes, imploringly, begging you to make an exception, begging to be spared. What would you do? What sorts of questions would you ask of yourself? How would you go about deciding whether mercy was or was not the proper course? As jurors in this kind of setting, we'd all be in the position, I think, captured so vividly by the parable from chapter 8 from the Gospel of John, when Christ encounters a mob at the gallows on the brink of stoning an adulteress, and he admonishes them to consider if they are virtuous enough, if they are, as Christ famously puts it, sufficiently without sin to feel comfortable proceeding, to feel like they stand on good ground in judgment of others. Of course, in the parable, all the would-be stonecasters respond by simply and quickly putting down their stones and all walking away. In the real world, this is not always how it goes, of course. But the more important point is this is not how it should always go. In fact, the moral quandary of mercy in real life is far more difficult than the parable makes it out to be. The biblical story, I think, captures nicely, canonically, the form of the relevant question, which is deeply introspective, addressed to the individual in their capacity absolutely as an individual to decide for themselves when faced with the very serious business of standing in judgment of other fallible human beings. But the story captures none of the psychological or existential turmoil that this question can and should involve. When it comes to justice, I think we're all fairly familiar with the idea that there are hard cases and easy cases, cases that can be quickly disposed of and cases that require more attention and care. When it comes to mercy, I'd want to suggest that all cases are hard cases in some deep sense, and that it's never an easy decision to extend someone or to decline to extend someone equally an undeserved benefit. And the difficulty lies precisely in the benefit's undeserved nature. That's what guarantees the absence of determinate criteria. And to be clear, this aspect of mercy can, and I would say should, be a potential source of great moral agony. We can imagine jurors in a case like Valjean's, for instance, throwing up their hands at some point in frustration, basically saying, enough already. I don't know what the right course of action here is, and in some sense I never will, at least not in the same way I might claim to know or aspire to know what justice requires. When it comes to mercy, the only thing I can know for sure, sort of formally, categorically, is that at some level I'll never reach the right answer. I'll never be sure. So what is the point? We can see how this might be tempting, but of course it can't really be the end of the matter. To a juror who expressed frustration of this kind, or imagine again if you were on the jury, experiencing a variant of that frustration, describing it maybe to a friend or a loved one when you get home after a long day of hard, painful deliberations at the courthouse. The answer at some level would be, you have to keep going. It's a responsibility to keep going. It's difficult. Of course it is. Many responsibilities are. The moral integrity of law depends on not abandoning this task. So ultimately, as it relates to AI, I think the truly hard and kind of thorny question in all of this, and this is the question I'm going to leave us with to ponder, is do we think machines are capable of doing what I was just describing? Can they ever replicate? Or under what kinds of technological and social conditions might they plausibly be able to replicate the moral psychological experience of deciding whether mercy is due? What would it mean for machines to shoulder the terrible burden that mercy asks of us? Just before he passed away, Pope Francis was thinking a lot about the connection between AI, spirituality, and human flourishing, and he had a formulation that I think captures the essence of all this rather beautifully. Machines, he said, can make choices. Human beings, however, not only choose, but in their hearts are capable of deciding. Now, in one sense, of course, choosing and deciding are rough synonyms. We would use the two terms interchangeably in many settings. But what Pope Francis is getting at, I think, is the idea that for human beings there's something more that has to go on, or at any rate that often does go on and should go on in the face of hard moral questions. We don't simply choose the right answer, though we do typically try to get things right as best we can given our limited vantage points and so on. We also decide that we're willing to stand behind our answers, to to take responsibility for our answers and the sometimes very painful implications that they involve, and the agony that hard moral questions can provoke, certainly in the deliberation process, but often beyond that, often even after a decision is finalized, the lingering sense of guilt and uncertainty that can persist even once there is nothing left to be done, as it were. That agony is often the best evidence of our taking responsibility for our answers to hard questions, evidence that we are, in the words of Pope Francis, doing more than simply choosing. Now, I'm loath to say that machines could never approach judgment this way. I suppose I can imagine worlds in some kind of vague, amorphous, almost science fictional sense, where machines were sufficiently incorporated into our body politic, sharing in our values and commitments and joys and sorrows, etc., that they could be capable of taking responsibility for decisions in the way mercy demands. But that, I think, is the sort of thing that would be required for machines to plausibly perform this function, or at any rate, for us to feel secure delegating implementation authority to them to perform this function. They'd have to live among us. They'd have to share our world in a very deep way, not just materially, but psychologically, ethically, spiritually. They'd have to be capable of moral sentiments like agony. They'd have to be vulnerable and understand what it means to be vulnerable. They'd have to appreciate the idea of temptation and what it means to face it. They'd have to be able to experience shame. They'd have to be able to feel compelled or understand what it would mean to feel compelled to do something terrible out of fear that all of the alternatives are even worse. Only when machines can do that, I think, only when they become capable of understanding why a person tasked with judging another might decide to put down their stone rather than casting it, not because of what justice demands, but in defiance of what justice demands. Only then, it seems to me, will AI have solid ground on which to stand in judgment of human beings. Okay, thank you very much. I welcome your questions. So Anne is going to be calling on folks and passing the mic around, so don't be shy.
Yeah, so if you have questions, yes.
Yeah, I think the mic, yeah.
Okay, great lecture.
Thank you.
I wonder if there's some slippage between the moral and the political. That is, you've completely convinced me that I don't want AI making decisions for me when I confront issues of moral desert, mercy, and grace. But you, at least at the beginning of the lecture, said, well, you're going to relate this to ideas of democratic self-rule. In democratic self-rule, we have institutions, offices that are assigned particular roles. The president's pardon power immediately comes to mind, for example, or the governor's pardon power. And the question is, what's appropriate for them as representing us? And then the question is also, how well are they performing? So in my life, I might not want AI, but if the president's selling pardons, I might appreciate AI. So make the connection for me between your ideas of democratic self-rule, institutional responsibility, and the considerations of struggle that you ended with.
Okay, great. Thank you. So let me, by way of answering this, let me try to bring alive more. You know, I posed this question, what I take to be the kind of fundamental issue of political theory, which I am authentically ambivalent about for many of the reasons you've described. And then I sort of talked only about one branch of the tree, right? We talked a lot about what it would mean, what the implications would be if you take the view that mercy is integral to political freedom in this way. But what if we take the other view? I talked about some of the practical considerations that might follow from that view, governance concerns, institutional design. But I take it that part of what you're pressing me on here is to sort of take seriously what underpins the other position on this question. What might it mean, or why might somebody be drawn to the view that justice really is the only game in town, so to speak, and that in the end, if we had perfect ideas or instruments of justice, we wouldn't need mercy, and we might even see mercy as a kind of pathology. Why might I take that view, at least as it relates to political and institutional life? And once I say that, I can explain very briefly why I'm not totally satisfied with that view. So I take it the strongest argument in favor of the sort of it's all justice at bottom type of view, or that maybe you need mechanisms to refine the operation of rules, mechanisms that traditionally sound to a lawyer's ear in equity rather than mercy, but that once we refine everything, we wouldn't really need this space for mercy. That the arguments in favor of that view typically focus at some level on equality. So they start either with a sense of like cases should be treated alike, that's one type of equality, or they start with a sense of we should all abide by and be held accountable to the rules that we've all agreed to. That's a sort of a different and related sense of equality. Or they start with a concern that if you invite this space for mercy, what you're going to see is fundamentally unequal, at some level constitutively unequal, and at times grotesque applications of this discretionary power that the exercise of mercy must involve. And so if we're concerned about equality for one or multiple of those reasons, we might say, look, you know, mercy has perhaps historically served an important role alongside equity to try to refine the operation of law in particular cases, but that if we really could figure out how to refine our legal rules, or we really could do things like AI might allow us to do, like micro refinement of rules in real time, depending on the circumstances, then we really wouldn't need mercy. And indeed, we would see mercy as, again, a kind of bug rather than a feature. On this account, you could, you know, somebody who was of this persuasion might reasonably say, at least in the context of secular liberal public institutions, something like, you know, you talk a lot about Aquinas and this position on mercy, but that's all cautionary, or that's all a reminder of what we left behind with this sort of modern turn in our political life, right? I mean, one might think about sort of Aquinas and Shakespeare on mercy and say, good riddance. They have articulated for us a view, maybe not the only one, but a plausible view, if one starts with precepts that do not see human beings as in charge of their own fate, but now that we are in charge of our own fate, in this way that democratic self-rule promises, we should discard mercy. So that's a view we're taking seriously, the sense in which I am genuinely ambivalent, and I sort of invite you to be ambivalent and reckon with it for yourself and decide, as Pope Francis would say, you know, in your heart, which one you think is right. Is it justice all the way down, or is there some room for mercy? What I'll say in terms of the final plea, so to speak, for mercy here, or for some room for mercy, even in the last instance, even once law is perfect, is that there just seems to be some sense that we aren't fully free, or at any rate, I take it this is the core intuition behind the kind of mercy view, that we aren't fully free unless there's some way for us to decide that we don't want to go there. We can have fashioned at time 1 rules for ourselves that at time 2 we want to be relieved of. And the mechanisms for doing that are deeply imperfect, and they can't possibly look like the mechanisms that we use for fashioning the rules at time 1, because if they did, the whole thing would just become about fashioning rules. They have to be decentralized and unaccountable or radically free. And that these risks that you've identified, selling pardons, and I mean, we could probably distinguish some cases as not actually mercy or sort of pseudo-mercy, but the hard cases are cases like, the judge who sentences Brock Turner and says, you look like a promising young man, and I know you've been convicted of rape, but I don't want to ruin your life. I'm going to give you a slap on the wrist. Or, the evidence that's pretty unequivocal empirically that when it comes to the death penalty, the administration of it on this sort of same facts is largely predicted by whether the victim is white or not, which is a sort of pernicious exercise of mercy, these things. I just think that's a risk that we have to be comfortable with if we care about mercy, if we care about this sense that we don't just want a world where we've fashioned everything to kind of run of its own accord. Our institutional life involves choosing at every moment whether we are willing to follow through. So I think that's the kind of core account in favor of mercy, or seeing individual applications of the law and acts of judgment as expressions of political freedom. I'll note just the last thing is that this debate, I referenced nullification, jury nullification. There's to say it's divisive would be an understatement. There's radically split views about this, camps on both sides who are really entrenched. And the folks that are against it say roughly what I just said in favor of the justice all the way down view, or they say roughly what Paul said in the question, I think. The folks that are in favor of it, they say, wait a second, the jury deciding whether in that actual moment, when it is facing Valjean or whoever, whether we actually have the courage of our convictions in applying this rule, once we exhaust considerations of justice, that is a fundamentally democratic act. That's the point where we get to decide. In that case, it's we 12 people, not we everybody, but it is a we, whether we are willing to follow through. So at any rate, I think if you like that, then you necessarily sort of invite some risks of the kind that you've described, and then it becomes a question of how to parameterize them in practice.
Okay, another question? Yes, in the back there. There's a microphone coming to you.
So thanks again for a great talk. I do care about what Aquinas says. And one of the things I was thinking about his conversation of mercy and justice, and for Aquinas, mercy perfects justice. We're talking about, is there a way of having perfect justice? And I wonder if we're going too far into either we treat somebody with justice all the way down, or we try some mercy out that could get a little uncomfortable because it doesn't have... And I wonder if there's a way of seeing these two things working together so that you can't have mercy without justice, and justice becomes more perfect with mercy. And I wonder if that's a way of understanding, the relationship between these two things, but maybe dealing with some of the ambivalence that people might have on both sides, that these things, it isn't an either or, but it's one presupposes, I think is what Aquinas says, and then makes more perfect the former. So I don't know if you have any thoughts on that or that's helpful.
Sure, yeah. It's a great question. So for the scholastic theologians like Aquinas who were perplexed by this problem, obsessed with this problem, the reason they were so concerned about it is because for them it was axiomatic that God's nature is both just and merciful. They weren't going to abandon that. And so they wanted to explain how the two could reconcile, and they came up with a variety of different answers. I think that whether Aquinas has the view that you described or not, that view is definitely sort of available, and I think kind of present in both the old philosophical discourses and also in our presently configured legal institutions and legal theory today. So there's some idea that maybe I'm being too hermetic, or at any rate that I'm taking a particular view that might itself be too hermetic about justice and mercy, and that the two might be mutually reinforcing, one might presuppose the other. There's different, very kind of precise formulations of it. But so two kind of observations about that. One is that at the kind of bottom line in terms of the implications for AI, it's like, what should you walk out of the room, thinking? It's like, I'm not trying to proselytize, but just if any of this was right and it helps you structure your thinking, if you see mercy and justice as more commingled, in whatever exact analytic sense we might shore that claim up, but if the sense is that mercy and justice run together more, one influences or underpins the other, perfects the other, that sort of thing, if they're not separate in this way I was making them out to be, that should, I would think, give us even more reason to be skeptical of turning implementation authority over to AI. So in some sense, the way I'm setting this up is to try to give AI as much room as possible, so to speak, by kind of isolating this particular version of mercy that may be of the possible theories of mercy and justice, the most hermetic one, but that if we have this one, then we can see pretty clearly the domain, namely the domain where mercy would still matter, where AI is just like kind of not going to be able to do it for us. You might think that that domain is larger than I'm making it out to be, and that in many contexts, actually, mercy and justice are going to run together in a way that if we take this mercy business seriously, we're going to want to be cautious about delegating authority to AI on the mercy ground, because mercy is actually more ever-present or evergreen than I'm describing it. So that's one observation. I mean, the other thing I'll say is that there's a very clear alternative tradition that you can trace through the kind of the ancients, and it goes back to Seneca. I think he's the sort of progenitor of this, but it's definitely live in kind of 20th century and 21st century legal theory and maybe legal practices that would say something like a merciful attitude, being kind of open to the complexities of the world and the way in which, there before the grace of God go I, people don't fully determine the own conditions of their action, and life is messy and complex and requires compromises, and far be it for me to judge somebody, put down my stone. All that mentality helps us see what justice requires in a case. So we don't need to have necessarily a strong analytic sense of the relationship between justice and mercy in this way you're making it out, though that's possible. But we could just say something like, well, if I have a merciful attitude of the kind that's cultivated through things like family of origin relationships, teaching, reading lots of literature, hanging out with people, trying to be the best kind of person I can be, religiosity, you can get it from lots of places. But if I have that attitude, I will have an easier time seeing what justice requires. I'll have an easier time just adjusting course rules in response to the particularities of cases, not in this kind of beyond desert, mercy that's infinitely radically free kind of way, but just in the way that it helps me see things. We have a, I think, sense of this in our lives, that if you're open in a certain way, you can see just the empirical realities or factual complexities of things in a different way, and that at a minimum should be a reason to kind of cultivate what you might call a merciful attitude in people in the future generations so that they'll be able to do the project of justice. I think that's a perfectly plausible view, and that it's not really in tension with anything that I've said, and certainly as a teacher and in other roles in life, I think that's tremendously important. It doesn't really solve the question, if you take it seriously, that Aquinas is so puzzled over about justice and mercy in the analytic way, but I think it maybe gives us a sense of what our own practices and experiences are.
Thank you. Great talk. I think a lot of people in the kind of Silicon Valley, either like the right-wing flanges or the center-right kind of flanks, talk about AGI, like artificial general intelligence, as this kind of potential boon for humanity with regard to like scientific breakthroughs, curing of cancer, et cetera, et cetera. And I love what you said about like agony and envy and shame kind of being these integral parts of humanity. And I'm wondering like to what extent you would square that with, if we reach AGI, if we get enough compute to develop AGI, what would happen in that regard, or how you kind of square that or grapple with that, or just, rationalize that broadly is my question.
Mm-hmm. Yeah, it's a good question. So I don't always know what people mean by AGI. I'm not sure they know what they mean. I mean, not in a terribly pejorative sense. I just think it's as much a kind of fantasy, or a teleological aspiration as it is like a specific set of concrete technologies that people are envisioning. I do think, and this is a useful occasion to sort of clarify here, that it could be that AI, whether AGI or just sort of normal AI, but in its more advanced forms coming down the pike, will be incredibly good at helping us with, and maybe even taking full ownership over, in some sense, domains that don't require normative judgment in the sense that I'm talking about here. So identifying, medical conditions and prescribing some course of, care or something like that. I mean, I think pretty quickly anything that lives in a human institutional environment is going to start to require lots of normative judgments. Certainly it's going to have distributive implications, political economy, who's getting the care, all that sort of stuff. But in some clean way, we can say, well, look, like AI might be able to do things like tell us how to optimize where our parking lots should be constructed, or like tell us like which subtype of melanoma this is and what the prognostic considerations might be because of its pattern recognition capabilities or whatever. And that whole realm of AI stuff may still be on the table, even if you take everything that I've said quite seriously. At the same time, the flip side, if we are talking about realms that clearly involve normative judgment, one way to express my skepticism in kind of different language than the talk, but would, hopefully be consonant with the arguments I've developed in the talk here, is that at some level, normative judgment isn't really about intelligence. So, I don't want to get too fixated on the label of artificial intelligence. That's more of a meme. Again, it's an aspiration. It's not a set of concrete. But like, at the end of the day, what we would really need is something like artificial virtue, right? Or we would need sort of artificial lived experience that allows for the kind of consideration and reckoning that I'm describing, not necessarily in every single domain of law or legal institutions, but in general, that's the capability or that's the set of thought processes that we would be, looking for. And some virtues, like the classical virtues, it's like justice, temperance, fortitude, prudence, like maybe justice is not reducible to intelligence, but it is perhaps amenable to the application of tools that fly plausibly under the banner of intelligence in the sense that it's about taking factual inputs and subjecting them to some agreed upon function and then spitting out answers in all the ways that you all are learning how to do or do a lot of the time. That is the legal profession, and of course it often requires or at least rewards intelligence. But a lot of those other virtues, particularly I think prudence and temperance, are not really about intelligence at all. They are things you cultivate. They, in some sociological contexts, probably trade off against intelligence in certain ways, or some institutional environments that reward intelligence do not reward these things whatsoever under XYZ political economic conditions. So that's the sort of thing that I think we would be needing to aspire to in our technology, and then there's a different set of questions about how we would actually get there, but it's notable to me that that's not even what we seem to be aspiring to.
So some thinkers have suggested that just punishments have a salutary effect on the soul of a criminal, and if that were true, if just punishment rehabilitated a criminal, it would mean that, that would lead to a situation where to deny a just punishment would be harming the criminal. It would be to harm his soul in a way. So in your opinion, does mercy require some presupposition that punishment for a crime is a bad thing?
Okay, good. So I think I have focused here on the implications of justice and mercy and their interrelationship for thinking about democracy and public institutions as a manifestation of democratic self-rule. And the puzzle is, what does it mean exactly? And it goes back to the first question, why might within a kind of democratic framework we care primarily about justice, or why might we become suspicious of mercy, et cetera, right? Another way of thinking about justice and mercy, or another kind of question that one might ask, is very interesting and connects, I think, with the AI stuff as well, is what are the implications of justice and mercy as it relates to the particular affected party? So not so much, that's of course connected to questions of democratic self-rule, but it's a different question. We might ask something like, what kind of treatment is due Valjean, or whoever it is, right? And there you might say, well, the account I was offering in the talk, roughly Aquinas' account, extrapolated to the setting would be something like, well, we should figure out what justice requires. We'll look at the law, we'll look at the statutes, we'll do all the lawyerly stuff, and then we'll try to make adjustments about the course rules in this particular context. But then once we do that, Once we've exhausted that, we still have this mercy question to ask, right? Which is something that the decision maker has to largely do introspectively and ask of themselves and so on. But a different way of asking this might be, well, what's best for Valjean, right? There's an account that would say what's best for Valjean is to be punished justly. Not because of its connection to democratic self-rule and the concerns about equality and so on, but because it's good for him. That would be the account that you just sketched, and we could figure out its exact contours. There's a different kind of account. I suspect it's a more familiar, at least a more widespread account in a room like this, but I'm not sure. It's just a guess. That would say that some degree of forbearance, or at least its possibility, is good for Valjean. That actually this idea that doling out a just punishment is good for the party receiving the punishment in a spiritual sense or otherwise. We can imagine cases where that might be true. I mean, punishment sometimes does help people rehabilitate or become better. But that more often, and certainly against the backdrop of our actual criminal punishment institutions, that the problem is the other way, that what we need is more mercy and space for forbearance. This too has a deep lineage in a lot of, I'm sort of drawn to the Catholic variant of it, but you can find it in lots of different traditions, deep political theology. And the mercy position on that one, or the kind of pro-mercy view, would be something like, mercy is not only good for the person in the sense that it might allow them to walk away, like Valjean would say, whew, they gave me a pass even though it was undeserved, but that mercy has a kind of healing quality. It invites redemption in a way that just punishment cannot. That is to say, the reasons that one might think just punishment is good for the offender don't have to do with redemption in the same way that mercy seems to invite redemption. They might have to do with rehabilitation in a different sense, but they don't invite redemption in the way that mercy might. So, I was really hoping, I told Anne this, I was really hoping somebody would ask a question about Les Mis, which no one has done yet, but I'm going to construe this as a question about Les Mis. And think about the moment in Les Mis where right after Valjean is paroled, what does he do? First thing, he's out in the world. He goes and he stays over at the bishop's house and he steals a bunch of silver and he gets in trouble for it. And they hail him back there and he said, and the constables say, he made up some story about how, you gave him the silver, like that's a bunch of malarkey, right, Bishop? And the bishop shows mercy on him. It's a profoundly moving moment, It's a beautiful moment, right? And there's some sense that, as the bishop says in the song or, in the novel, that this is the beginning of the possibility of redemption for Valjean. That this act of mercy is sort of helping him along a path that's not rehabilitative in the sense that your question has in mind, but is a different kind of salvific possibility to it. And I tend to think that's sort of true in formal institutional environments as well. I'll give you one more thing on this, which is Pope Francis has a lot of very eloquent things to say about a lot of this, but he has a nice formulation at one point where he says the reason why he thinks mercy is important and kind of exists alongside but is never reducible to justice is that justice has the capacity, this is his formulation, to check evil. It can keep evil in check, but only mercy can conquer it. Only mercy sort of opens up the world into the future in a way that seems to make possible the kind of transcendence that we associate with salvation. Now, if you care more about things like rehabilitation in the sense that you're talking about, which we may well care about, then you're not going to take that view, but I think those are sort of the incommensurable versions of helping the affected party move forward in the world.
I think that's a beautiful moment to end right there.
Thank you,
Yes.
everybody.
Thank you
this
so
was
much.
lovely.